Welcome to the Family Law Frontline.
Welcome back to the Family Law Frontline with Fedor Kozlov. Fedor is the founding partner and chief litigator at the law office of Fedor Kozlov, PC. With over a decade of experience in Illinois family law, he handles high stakes cases involving custody, property division, domestic violence, and complex divorces. I'm Shameika Rhymes, and today we're talking about orders of protection in Illinois and how they can affect custody and parenting rights. Welcome back.
Nice to be here.
Great to see you. Well, Fedor, when an order of protection becomes part of a custody case, what circumstances usually lead someone to seek one?
The order of protection is a very strict measure. What it is pretty much asking one person is asking for some kind of protections against the other. Um, and that person can also include uh, other people, such as children or parents, um, in the order of protection. The order of protection prohibits certain acts for alleged abuser, such as you cannot follow the victim, you cannot text that person, you cannot make any threats or physical contact, and you cannot reside in the same household. Although I had a case once when a father, a mother issued an order of protection against the father, and he was allowed to live in the basement, which didn't make any sense and did not end up good. But usually, people are prohibited from going to other people's residence. So, what leads to somebody filing for the order of protection is some sort of allegation of abuse. So, there has to be some kind of unwanted contact from one person to another, and that's what usually leads to filing petitions for the order of protection.
Well, what types of orders of protection exist in Illinois and how do they differ in terms of the duration and the legal impact?
So usually, from my experience, the order of protection starts with what is called ex parte petition for the order of protection. Ex parte petition for the order of protection is a petition that is filed by, again, alleged victim in court without the presence of the alleged abuser. So, usually we need to give some kind of notice to the other side. But when, I should say, emergency order of protection is filed, the victim says, well, I'm in such and such danger that I don't have time to notify the other side, and I need to go and talk to the judge today and ask for this order of protection. So that's what called emergency order of protection, and it's usually, if granted, it goes for 2 weeks. So once the order of protection is granted, police has it. Police will go and serve the alleged abuser, and abuser has a notice. A person has a notice. It usually goes for 2 weeks. The reason that it goes for 2 weeks is because sometimes people do things either under influence of alcohol or drugs, or it can be emotional, or something not out of ordinary, something that they usually don't do. So the judge wants to see in 2 weeks, when people go back to the court, if the alleged victim still wants to proceed with the order of protection, or she or he wants to dismiss it. If the person, the alleged victim, wants to proceed with the order of protection, the judge usually sets a hearing. The hearing has to be set within 30 days of this process, and that's when the hearing is held for so-called plenary order of protection. A plenary order of protection is the order of protection that can go for a longer period of time. From my experience, it's usually 2 years, although I've seen orders of protection, plenary orders of protection, going for 1 year, going for 6 months, so on and so forth.
So, when a court enters an emergency order of protection, what can happen immediately in terms of custody or parenting time?
We're assuming that the um, alleged victim has the children, uh, uh, and the children are a part of this order of protection. Usually, any visitation or contact between the alleged abuser and the children are suspended until other orders of court. But this is the usual circumstance, and again, why? Because it's ex parte order of protection, so there's no time for people to discuss things. So it's more like an emergency basis. One person says, I don't want to see this person anymore, and I don't want him or her have contact with the children. So usually no visitation is discussed at the time. Any visitation or any contact is immediately suspended.
Well, can you walk us through a case where an order of protection significantly changed the direction of a custody dispute?
I would say that orders of protection, there are many, many cases I can talk about. They are somewhat similar, but somewhat different. The I should say this: I deal with orders of protection almost on a daily basis in a custody cases or divorce cases. I do not believe in the orders of protections themselves on many different levels.
Mhm.
I used to work back in many years ago, even before becoming a lawyer. I was advocate for the victims of domestic violence, and I work for different non-for-profit organizations representing victims of domestic violence. In order of protection, just a piece of paper. And that's what people have to understand. So if you are
Mhm.
in grave danger, that piece of paper is not going to save you. That's one. Two is that
Okay.
the order of protection. Um, if you have a family and you have kids and you go through the order of protection process, uh, at some point of time, because even if you know even if your order of protection is granted and you have plenary order of protection for 2 years, the father, let's say it's the father who's an abuser, will still have the right to see the kids. So, and then the court has tools for the father still be able to communicate with the mother as far as the visitation goes. It goes through talking parents, the applications on your phone, talking parents, or our family wizards. So this order of protection sort of protects you from maybe getting a home for yourself, so the person wouldn't follow you in public. But as far as the custody, to answer your question, as far as the custody goes, there's going to be a child representative who will be appointed to the children, and the father will have the ability to see the children anyways. If you're in boyfriend girlfriend relationship and you have an order of protection, but again you have kids, same thing applies. Like you need to decide between yourselves how to go about visitations and things like that, because with child custody, everything you do has to be in the best interest of the children, and depends on the age of the children. You would still have to communicate with each other. You would still have to go to school events. You need to go to through extracurricular activities. You probably will be at the graduation ceremony and parties, so you still will be, you know should be able to communicate. And at some point, orders of protections dismissed or reduced to what's called no contact orders. No contact orders is just a civil order. The difference is, if somebody violates an order of protection, you can call the police and the person will be arrested. With the no contact order, if the person violates another no contact order, nobody's going to arrest it. But again, order of protection, if you're in great danger, you probably need to talk to state's prosecutors. It's something serious that you have to, defend yourself, protect yourself. If it's in a family circumstances, you have to realize that the order of protection will not resolve your case. It might complicate you. I'm not telling you not to file it. This is something that you can obviously entitled to file if you feel that this is the way to go. But it's not going to change the custody dispute drastically.
Well, beyond parenting time, what other restrictions can an order of protection place on a parent during litigation?
Many restrictions. The order of protection prevent you from abusing the other side via text messages, or The court monitors how you communicate. The order of protection prevents the alleged abuser from going to the place of work, or sending you any communicating with the other side by via third parties, parents, siblings. Sometimes the order of protection works as far as a party will get a peace of mind in terms of, again, with the exception of only one case that I had during the whole my practice, when the person was allowed to stay in the basement. And the basement, by the way, didn't have restrooms. So the person that stayed in the basement, in that case, the father would still have to go upstairs to use the bathroom. But the order of protection said that he could only stay in the basement, and that was not a walk-in basement either. So he would violate the order of
Mhm.
protection either way. But he violated it in a
Mhm.
different way. But again, it just was something unique that I recently
Right.
encountered. But usually, the person is removed from the household. That is one of the reasons for the order of protection. So there is not an ongoing dispute between people. The divorces
Mhm.
can be emotional, and uh, even if before filing for divorce, because you can file order of protection at any time, and there is no limit on filing orders of protection. Even if the order of protection was granted, I mean dismissed, you can still file another order of protection. And that's one of the reasons, by the way, I'll step away for just a second from what we're talking about now, is that why I don't believe in the orders of protection. So let's say you have an order of
Mhm.
protection, right? And you have to, it's an emergency basis. So it's 2 weeks, and now you have to set it for the hearing. So you set it for the hearing. That if you go through the hearing and you cannot resolve your differences, you go to the hearing, you present your case, and the other side presents his or her case. So there are only two possible outcomes. One, you win, another one, you lose. Okay, so let's say you win. Um, Again, as we talked before, there's still going to be a process by which the other side will be able to see the children. So it kind of complicates things. But let's say the other side won, right? So, and I presented people on different sides of the spectrum. So I presented people, alleged abusers, and who would say, well, this is not true. I did not do anything, that the order of protection should be dismissed. And if it's dismissed, so what's going to happen next? Let's say it's a mother, a wife and a husband. Mother had an exclusive possession of the husband, of the house. Order of protection just got dismissed. What the husband is going to do? He's going to show up at home, and it's just going to be another argument, and there's going to be police called again, and there will be another order of protection. So order of protection doesn't really resolve things in my mind, if again, if we're not talking about dangerous situations. But sometimes it works on a temporary basis, so a person can have her peace of mind. She will stay in the house with the children. There's no abuser in the house. She can kind of get the thoughts together and see what's next step should be.
So, how do the courts balance safety concerns while and with maintaining a parent child relationship in these situations?
They usually, if there's an order of protection, and if there's a sufficient allegation that there could be a danger towards a child or children, the court might appoint either a supervised visitation. Supervised visitation can be done by different means. You can go to a certain location that provides supervisors and will be going to be inside, or sometimes a parent, like a grandmother, a grandfather, can supervise the visitations. Sometimes court appoints
Mhm.
GAL, child representatives, who can also supervise those visitations. Parenting coordinators are very common. So, and then it'll be done on limited period of time, usually no overnights in cases like that. And 99% there are no overnights when there's an order of protection and supervised visitation. Then you'll have a limited period of time, let's say 3 hours every Sunday, to see the children with the supervisor, because court is always mindful about the time of the supervisor. And if it's a professional such as GAL, everybody have to pay for, 50, it's usually 50-50 split for GL's time. So courts are usually mindful of that. And it goes for a limited period of time, usually about a month or so, just to see how this parent is doing with the children. If children are afraid of their father or somebody else,
Hmm.
and if everything goes well, then court goes to the next step and expands the visitation period of time.
Well, to wrap up, for someone involved in a custody dispute where an order of protection has been filed, how should they approach the process moving forward?
Well, it depends if this is the, again, I'll say alleged abuser or alleged victim. If there's an order of protection filed and this is an alleged victim who filed the um, order of protection, my practice, these are usually mothers or wives or girlfriends. If this is the case, you still need to understand and figure out um, how the other side will see the children, because he is still a biological parent, or if it's an adoption, or if it's same-sex marriage, or and there's an adoption, the other side will still have uh, must have ability to see the children, with exception only of extreme situations. What also plays in, and I keep saying that over and over, there is a legal system, there is your life. We all go to work every day, and depending on the age of the children, somebody has to go and pick them up, somebody has to go and bring them to extracurricular activities, somebody has to take them from the daycare, things like that. And sometimes daycares are very expensive, and let's say the other side can stay with the children at that time. So it all plays significant part in that decision making which you have to make. If you are on the other side, and there's a petition for the order of protection, well, there's something that you have to adjust about yourself, I guess, and it's only also about the practical point. I think that people don't file these things without a reason. So if there's a reason, and even though if you're contesting the reason, and there are other arguments that can be made, if you still want to see the children, you got to adjust something, and hopefully you can dismiss this order of protection, and we can all call a misunderstanding, and the family can go back together. Or if the divorce is inevitable, it's always better to get rid of the order of protection, calm down, and figure out visitation schedule.
Thank you so much for breaking this down for us today. This has been an informative conversation.
Thank you.
Well, that is it for today's episode of the Family Law Frontline. If an order of protection is affecting your custody case and you want to understand your legal options, visit lawyer-il.com to connect with Fedor and his team. Thanks for listening, and don't forget to like, subscribe, and leave a review if you found this episode helpful.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.